Hey there, I'm the MadCatster. Happy Halloween, and am I glad to see you here because we've got more breaking news on the SSSniperwolf lawsuit front, and you're not going to believe what her husband, soon-to-be ex-husband, Evan Sausage, and his attorneys had to say about her motion to dismiss his lawsuit. We've got their response. I've got the deets and all the receipts, so buckle up and let's go. I had to take those things off. Those things are metal and they're heavy and they're like digging into my nose. But which costume do you prefer? That mask or this one? Woo! Anyways, I'm here with Sybil the Enforcer, who is feeling better. She went to the doctor today. She got her pain medicine and her steroid shot, so her mouth is feeling better and she's up and about again. The other night she wasn't feeling so great. But anyways, Sybil says, please like and subscribe. We're almost to 30,000 subscribers. Can you believe it? So please like and subscribe. I also want to give a special thanks to Alex Elmsley, who's known as I'm Alex on his main channel, for giving me a great shout out. I appreciate it. And I want to thank Atozy for giving me a shout out. And I want to thank Tamimi for giving me a shout out. And I thank you so much for helping out this little channel as we continue to grow. So Amelie is here to say thank you to a couple of people real quick who sent us stuff from Amazon. Thank you so much to Samantha C., who sent us a case of Frisky's wet cat food. We really appreciate that. And I want to give a big shout out to Laundry Art, who sent us this really nice collapsible cat carrier, which when you have as many cats as I do, the cat carriers take up so much space. It's really nice. It's nice and lightweight. It's easy to store, which I love. And also some Rachel Ray dry cat food, some Blue Buffalo wet cat food. Thank you guys so much for all of your generosity, as always, from the cat's Amazon wish list down in the description. You remember we talked about after Sausage filed his lawsuit, SSSniperwolf filed a motion to dismiss. It was that ridiculous motion where she, or her lawyers I should say, started it off by titling it gaslighting and had that ridiculous baseball like word problem, and basically made a whole bunch of vague arguments as to why the court should dismiss the lawsuit that Sausage filed, and or why it should be moved over to family court where their divorce is currently pending. And of course, it's all such nonsense. And now Sausage and his attorneys have filed their response, or sometimes known as an opposition, to her motion to dismiss. And boy, they do a great job, as always, of running circles around SSSniperwolf's attorneys and showing why it should not be dismissed. So without further ado, here you'll see it says, in the Superior Court, State of Arizona, plaintiff's response to defendant's motion to dismiss. Plaintiffs Evan Young and Channel Red LLC hereby, and remember Channel Red is the company that they created basically to be the parent of their SSSniperwolf brand and empire. It says hereby file their response to the motion to dismiss, filed by defendant Alia Shelesh, who is SSSniperwolf. I keep saying that, but SSSniperwolf is actually a brand, but I'll call her SSSniperwolf just to keep things simple, or I'll call her Alia, but Alia Shelesh, filed by Alia Shelesh. You know, I was talking about the couple of pleadings that her attorneys have filed and how I thought they were so sloppy and so badly done and improperly formatted and things. This is how you do a motion or objection to a motion. The introduction here will give you sort of a succinct recap of the state of affairs. So Young and Shelesh are husband and wife who are in the midst of a divorce proceeding in family court. The actual entry of the divorce action I've shown you guys before. And so more than a decade ago, Young and Shelesh formed a business venture in which they created content for their YouTube channel known as SSSniperwolf. Both Young and Shelesh played important but distinct roles in the business venture. Young created the SSSniperwolf channel and the scripts for the content. Shelesh was the face of SSSniperwolf, who read the scripts while Young filmed her. The videos were posted online to the party's YouTube channel. The parties formed Channel Red as the entity through which their business venture operated. The business venture was highly lucrative, to say the least. Unfortunately, as their marriage frayed, so did their business relationship. We know that Evan Young, known as Sausage, had filed for divorce last October in 2022. And it was so funny because in my last video when I talked about her counterclaims and her answer, when she talks about him beating her to the courthouse, Shelesh initially brought suit against Young in a different action, claiming that Young had restricted her access to their YouTube channel, but acknowledges that she allowed that action to be dismissed. And we've talked about before about the lawsuit, how she last year in 2022 had filed a restraining order, or asked for a restraining order, against Evan Sausage because he had locked her out of the YouTube channel SSSniperwolf, and she apparently had stolen some hard drives, and she had locked him out of social media, and there was this back and forth. But eventually they came to a kind of a truce and a ceasefire, and in fact they created what they called a ceasefire agreement. And so things seem to get back to quote-unquote normal until we've reached this point. It says plaintiffs thereafter filed this action against Shelesh on August 12, 2023, asserting claims for breach of fiduciary duty, breach of contract, breach of implied covenant of good faith and fair dealing, tortious interference with contractual relationships and business expectancies, conversion accounting, and for the appointment of a receiver for Channel Red. On October 10th, Shelesh filed her answer to Young's complaint, and that's what the last video I did was about. So if you haven't seen it, go back and watch it because it really breaks down her answer and sheds light on how weak I think it is. It says, on October 10th, Shelesh filed her answer and asserted counterclaims for breach of fiduciary duty, declaratory relief, breach of contract, breach of the implied covenant of good faith and fair dealing, and dissolution of Channel Red. So she also had asked the court to actually break up the company, which really would work in her favor. So of course that's what she wants. It says Shelesh now moves to dismiss all of plaintiff's claims, asserting first that Young's claims are more properly asserted in the family court proceeding, the divorce proceeding. This despite the fact that Shelesh has filed counterclaims in this case that essentially mirror Young's claims. And we talked about that, how in her counterclaim, she's basically asserting some of the same claims that he asserted in his complaint, in his lawsuit. And what I thought was hysterical was she too has asked the court for an accounting and asked for the appointment of a receiver. Now, when she filed her motion to dismiss, basically she had criticized his wanting an accounting and a receiver and saying that it wasn't appropriate and blah, blah, blah. And then she turns around and she's asking for the same thing. So, you know, it's like she's all over the place. They don't seem to have a very cohesive or coherent strategy here. And it says she's moving to dismiss some of his claims pursuant to Rule 12b-6, which is, it's a rule of civil procedure that gives you reasoning for when you can ask the court to dismiss something. And she's asserting that the claims have not been sufficiently pled and therefore fail to state a claim. As shown below, these arguments are either wrong as a matter of law, require the court to evaluate the evidence, which the court cannot do at the pleading stage, or to put plaintiffs to the task of proving their claims, which is a burden plaintiffs do not have at the pleading stage. In other words, their motion to dismiss was almost like a motion for summary judgment, we call it, where you ask the court basically to enter judgment in your favor. And even though they were asking for the court to dismiss his action, it was still, that's sort of what it was like. And what he's saying is, correctly, at this initial stage, the court can't consider a motion for summary judgment because all the evidence isn't in. And we don't know what the evidence is going to be. This is just the beginning stage of the lawsuit. And so correctly, he states that that's not something that the court can do or consider at this point. Finally, plaintiffs note that the motion is filed with invective. And we talked about this, how it was just like this personal attack, and they use all of this hyperbole to, you know, paint him out to be some kind of a lunatic. And it says, accusing Young of having acted vindictively, surreptitiously, engaging in behavior that is nonsensical, spiteful, and unhinged, and accusing Young of gaslighting Shelesh. These ad hominem attacks are particularly inappropriate in a motion to dismiss, where Young's factual allegations, I love the way they say that, Young's factual allegations, in other words, what she's saying is, it was so vague that you can hardly call it fact. It's really just a lot of vague discourse, in my opinion. That his allegations must be taken as true, because it's a very high burden. I said before when she filed her motion to dismiss, in the video I did about it, that courts don't lightly dismiss things at this stage, okay? Because the defendant's burden is very high to show the court why there's a compelling reason the court should not let the lawsuit proceed. And it's very rare. I've rarely seen a case get dismissed at this point, unless there's just glaringly obvious facts that show that the lawsuit is absolutely without any merit whatsoever, and it would be ridiculous to waste the court's time and everybody's time to go forward. And in this case, I certainly don't think that's the case. It says Young's factual allegations must be taken as true, and the issue simply is whether the causes of action Shelesh challenges state a claim for relief. Who did what to whom plays no part in that determination at the pleading stage. Once the hyperbole and vitriol is stripped away, the sufficiency of Young's pleadings rises to the top. So in other words, all they've been doing basically is insulting him, calling him names, making it sound like he's just off on a tangent and he's nuts. And that's basically their reason for why the court should dismiss the lawsuit. And it's just absolutely empty of any kind of substance. So here's their argument. They say that plaintiff's claims should be decided in this case not by the family court, especially because defendant has filed counterclaims. This does not really belong in family court, as we talked about in the video I did on her motion to dismiss, because these are contract claims about their business relationship and the company. The family court is there to ensure a fair division of the assets and to bring the marriage to a close. They're not there to litigate business contract claims. He says that defendant's lead argument is that the individual claims asserted by Young are best left to the family division in the dissolution proceeding, the divorce. However, the two cases defendant cites make clear that the quoted portion of this particular statute deals with the concept of waste, i.e. where one spouse accuses the other of dissipating joint assets. Apparently recognizing that the statute in cases she cites are specific to the domestic relations concept of waste, defendant insists that plaintiff's breach of contract and breach of implied covenant claims are simply disguised community waste claims. And they're saying that's not correct. Plaintiff's civil claims for breach of the Channel Red operating agreement and breach of the implied covenant of good faith and fair dealing implied into the operating agreement are not based on the domestic relations concept of waste, but rather on common law contract principles. In other words, the family court's function to determine the terms of the parties' divorce, including the division of community property, is very different from this court's function in adjudicating plaintiff's contract claims, which is what I just said. Even if the defendant's argument that permitting this court to determine plaintiff's claims would duplicate the family division's work, which I thought was the most absurd thing to argue, because it's not duplicating their work. They're not going to evaluate breach of contract claims. The defendant waived that argument by filing counterclaims in this case. So they're basically saying she's now filed counterclaims, which, as we've talked about, is a lawsuit within a lawsuit. So now she's got an active claim against him in addition to his original lawsuit with claims against her. So now it's saying that now that she's decided to do that, and remember I said before that usually you'll either file an answer or a motion to dismiss. Wait for the court to decide the motion to dismiss. If the court doesn't dismiss the case, then you would file your answer and your counterclaims. Well, she chose probably, like I said before, in my opinion, I'm guessing, that their motion to dismiss is really garbage. And so they went right ahead and right away filed an answer and counterclaims. So he's basically saying that that's why this gives even more validity to why this belongs in this court. Because now she's gone and asserted claims against him. And these are not things that the family court is really geared to handle. Specifically, at the time she filed her answer to plaintiff's complaint, defendant asserted counterclaims for breach of fiduciary duty, blah, 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 and dissolution of Channel Red. These counterclaims are based on the same business dealings between Young and defendant that are the factual basis for plaintiff's claims. So, in other words, she's citing to the same basically set of facts or circumstances that he cited to when he filed the lawsuit. So her claims are based on those same issues. So that's even more reason he's saying why this belongs in this particular court. And here they highlight by asserting the counterclaims after filing the motion. And again, that goes to what I said, that it was really strange to me that she right away filed this answer and counterclaims because the court hadn't even acted on her motion to dismiss yet. Defendant has conceded that this court is the appropriate forum for adjudicating the parties' claims against each other regarding their business dealings. So he's saying she's basically acknowledging that it belongs in this court because she's gone ahead and filed counterclaims. In addition, defendant's filings of the counterclaims act as a waiver of her right to dispute the jurisdiction of the court to hear plaintiff's claims. And they cite to a case here. And, she cited to a couple of cases, and I think they bring it up here, of New York law, because they couldn't find any, we call it on point, where she couldn't find any controlling or on point cases in Arizona to support her argument. She had to go all the way to the New York courts. And so this case that they cite to says waiver is either the express voluntary intentional relinquishment of a known right or such conduct as warrants an inference of such an intentional relinquishment. In short, this court should decline defendant's invitation to punt the adjudication of plaintiff's claims to the family court. And, I think that's a little tongue-in-cheek there that they're saying that. The legal standard for ruling on 12b6 motion to dismiss. And this is what I had said when I talked about her motion. It was completely missing from her motion. Usually you talk about the standard that the court uses to decide whether the motion to dismiss should be granted and what particular reasons the court would have to dismiss a case. And they didn't do that at all, which I found really bizarre. And so I won't go through this, but it basically talks about, what the standard is. And, like I said, it's a high bar for a defendant because usually the court has to view what the plaintiff is saying or alleging as true because we're at the beginning. We don't have the facts. The court can't make a fair assessment of the evidence because the evidence is not in yet. So the court has to assume at the beginning that the plaintiff filed this because they have actual claims. And so it's wrong to dismiss basically at this stage if what the plaintiff is alleging could potentially be found to be true once the evidence is in. It says plaintiffs have stated derivative claims and a pre-litigation demand would have been futile. And so they're saying here, defendant makes two arguments against the derivative claims asserted on behalf of Channel Red. They're saying that she said that plaintiffs had not pled any derivative claims. And even if plaintiffs have asserted derivative claims, they failed to make a pre-litigation demand as required by the statute. And they're saying defendant is wrong on both counts. First, the complaint makes clear that certain, you'll see, I've skipped over, I'm trying to keep this as brief as possible. I don't want you guys to get bored. So I'm highlighting, the meaty section. So it says, first, the complaint makes clear that certain claims are being asserted derivatively on behalf of Channel Red rather than individually on behalf of Plaintiff Young. For example, in their breach of fiduciary duty claim, plaintiffs expressly allege that Shelesh owed certain fiduciary duties to plaintiffs. Similarly, in their tortious interference claim, plaintiffs allege that Shelesh has intentionally and wrongfully interfered with the contractual relationships and business expectancies of Channel Red. Conversely, plaintiffs' breach of contract claim and implied covenant of good faith and fair dealing claim are clearly asserted on behalf of Young. So they're saying that basically some of the counts are more appropriate for Channel Red in his complaint, and some are more geared to just him. So it's really kind of a mix. Second, while the defendant is correct that plaintiffs did not make a pre-litigation derivative demand, Arizona law does not require a demand where it would be futile. Shelesh has admitted in her answer that she and Young jointly formed Channel Red. Both of them were listed as managers and members of Channel Red as of the date of its formation, and both of them remain as managers and members of Channel Red today. Shelesh and Young each own a 50% membership interest in Channel Red. Moreover, in her prior complaint, the one for the restraining order that got dismissed, Shelesh alleged that on February 8, 2017, Shelesh and Young organized Channel Red. Even though they did not enter into an operating agreement, they were both appointed co-managers and each owns 50% of the membership interest. And in the footnote, it says, although Shelesh denies this well-pleaded factual allegation, it must be taken as true for the purpose of the motion, which we've already talked about. So they're saying that last year in the complaint she filed with the court for a TRO against Sausage, she even stated that they both organized the company and that they own 50%. And if you remember, when we talked about her motion to dismiss and her counterclaims, basically her lawyers were trying to say that he duped her into making him a 50% member. And it's just total nonsense. So they're saying, she's basically confirmed the fact that they jointly formed the company and that they own 50% each. Thus, neither Shelesh nor Young have majority control over Channel Red, which means that even if Young had made a derivative demand on Shelesh for Channel Red to file claims against her, Shelesh certainly would have rejected or ignored the demand, thereby making the demand futile. And that's what I was talking about, but there's only the two of them. What's the point of asking her to stop? If he's asked her to stop already verbally and she won't, and she's the only person that comprises the board, it's absurd. Plaintiffs' direct claims have been sufficiently pled. Plaintiffs have sufficiently pled their implied covenant claim. I'm not going to go into a whole lot of that, but we'll skip down here. It says, with regard to this claim, and it says nowhere, and there's a case that they cite to, and I'm not going to go through the whole case, but in the case is Kramer. Nowhere did the Kramer court state that an implied covenant claim must be based on conduct distinct from an express contract provision, as defendant suggests. They're saying that this particular case says, to the contrary, the logical result of what the court said in Kramer is that an implied covenant claim can be based on conduct addressed by a specific contract term, albeit with the caveat that an implied covenant claim cannot be used to contradict an express contract claim. And then the reason they say is Arizona law recognizes that a party can breach the implied covenant of good faith and fair dealing both by exercising express discretion in a way inconsistent with the party's reasonable expectations and by acting in ways not expressly excluded by the contract's terms, but which nevertheless bear adversely on the party's reasonably expected benefits of the bargain. And they explain, thus, defendants' either or argument is directly contrary to established Arizona law regarding the implied covenant of good faith and fair dealing. Finding no support in Arizona, and this is they did talk about her going outside. Basically, her going off and starting these channels, by doing that, she's adversely affecting his interest in Channel Red's interests. So the operating agreement, even though it didn't expressly say she couldn't do it, it is wrong to do it because it's hurting the company. They said, finding no support in Arizona case law for her proposition that the breach of implied covenant must be based on alleged acts distinct from an express provision, defendant turns to two federal cases applying New York state law. Aside from the fact that defendants' New York cases are not controlling, as I said, they're not Arizona law, they also are inapplicable because they are based on a critical distinction in how New York law treats implied covenant claims. So in other words, the reasoning in these New York cases applied to certain New York law that affected those cases or the facts in those cases and have nothing to do with the facts in this case. And also, they're not even Arizona cases. They're not state or federal cases out of Arizona. They say plaintiffs have sufficiently pled their intentional interference claim. Defendant next argues that Young has failed to plead his intentional interference with contractual relations claim because he did not allege any breach. They're saying, well, he didn't say that she specifically broke a particular term. More specifically, defendant argues that her alleged interference did not cause the loss of any brand deals, but instead, as a result of Shelesh's interference, they actually signed deals. And we talked about in her pleadings how ridiculous that was because he's clearly saying that she went off and made side deals. And so how were they benefiting the company when she's pocketing that cash? And so Sausage is saying this argument misreads the allegations of the intentional interference claim. Young has alleged that Shelesh had knowledge of his contractual relationships and business expectancies as a 50% owner of Channel Red with Channel Red's vendors, merchant suppliers, and business partners. Young also has alleged that Shelesh intentionally interfered with these relationships and business expectancies, thereby causing damage to Channel Red and to Young as a 50% owner. These allegations are plainly sufficient to meet the breach element of an intentional interference claim. Moreover, Shelesh's argument that her interference did not cause any lost brand deals is a sleight of hand that ignores the fundamental point. By negotiating deals behind Young's back and without his knowledge or input, and then siphoning off the proceeds to bank accounts only she controls, Shelesh has diverted the contracts from Channel Red and Young to her own benefit. And that's what we're saying, that her whole argument that, she hasn't really done any damage is absolutely wrong because the allegation is that she started these channels, then negotiated deals that did not include Channel Red or Sausage or the original Sniperwolf channel. And that money wasn't going into the company to be split between the two of them. It was going into Leah's pocket. Shelesh unilaterally conspired with Channel Red's brand manager, Kevin Gold, to seek and enter into business arrangements and or brand deals with certain companies, including but not limited to G Fuel, without disclosing the details of the arrangements to Young. Shelesh retained all profits from these unilateral brand deals, including but not limited to those with G Fuel, in separate bank accounts, including but not limited to that certain bank account with First Republic Bank, without distributing any portion of the profits to Young through Channel Red or otherwise, which is what we said. That's what he was alleging, that she was making the deals on the side and keeping all the money. These factual allegations, which must be taken as true for purposes of deciding the motion, clearly suffice to satisfy the breach elements of intentional interference claim. So again, they're saying that, he's met the low burden that he has to show that he possibly has a meritorious claim, which should go forward, and that all of this stuff that she's stated in her motion to dismiss doesn't do anything to basically blow up that very lax standard that he has to meet in order to have his claim proceed. Plaintiffs have sufficiently pled their conversion claim, and conversion is like when you take an asset or take financial opportunity or money that should be going to the company and converting it to your own personal use so that you deprive the company of it. This defendant makes two arguments against plaintiff's conversion claim. The opportunities of Channel Red allegedly converted are not intangible rights of the kind customarily merged in a document. And I know this gets a little legalese, but stay with me. And with respect to the conversion of money, they said that plaintiff has not alleged a specific fund capable of description, identification, or segregation. And we talked about how ridiculous that was. Both of these arguments cherry pick plaintiff's allegations and call for the court to evaluate whether the factual allegations of the complaint suffice to prove a conversion claim, which the court cannot do at this stage. So again, the court can't make a decision on the merits of the case because the evidence isn't it. They can only look at it and determine whether plausibly the plaintiff has a claim and therefore his lawsuit should be able to proceed so that the evidence can be introduced, and then the court can make a decision about whether the evidence supports the plaintiff's claims or not. It says dismissal is appropriate only if, as a matter of law, plaintiffs would not be entitled to relief under any interpretation of the facts susceptible of proof. So again, as long as it sounds plausible as it's laid out in the complaint, then the court needs to let it move forward so that we can see whether the evidence is going to be sufficient. But, he's clearly met that very low burden to state that, based on his chronology and the things he's alleged, it sounds like there could be something there. So now we have to go forward to find out if there is something there. It says, Young has made allegations sufficient to plead a conversion of money claim. As noted above, Young has alleged that Shelesh retained all profits from the unilateral brand deals, including but not limited to those of G Fuel, in a separate bank account, and that the profits are identified by source, unilateral brand deals, and by where they were siphoned to, the separate bank account. And moreover, plaintiffs have alleged the defendant had a fiduciary duty to remit Young's equal share of profits obtained through the business and operations of Channel Red, which suffices to meet the requirement that Shelesh had obligations to treat the profits in a specific manner. Correct. The stuff that she was doing on the side rightfully should have been done through the company, and he should have gotten half of it based on the ownership of the business and the operating agreement. And she has, if you take as true what he's saying, and he's alleging, she has allegedly taken opportunities and converted them to her own personal gain and completely cutting him out. At the pleading stage, plaintiffs are merely required to plead elements of their conversion claim with some factual support. They're not required to plead all of their proof. That burden is for another day, and that's what we've been saying. The plaintiffs have sufficiently pled their accounting claim, and this, in her motion to dismiss, they were like, oh, there's no such claim as an accounting claim in Arizona. And then she goes on in her own counterclaims to state that she wants an accounting. It says, with no citation to authority, so in other words, she just stated that there was no such provision in Arizona law. She didn't cite to anything to support that. She didn't cite to a specific law that says no accounting is allowed. She just, said it and basically was like, there, I said it, so it's true. Defendant asserts that with exceptions she says are not applicable here, Arizona does not recognize actions for an accounting, and that an accounting is merely a remedy subsumed by the breach of contract claim alleged in count 1. The court surely is aware that plaintiffs routinely plead a claim for an accounting in cases involving business disputes where bank accounts or other joint assets are at issue. Those accounting claims are founded on this particular statute that they cite to all kinds of relevant stuff, relevant statutes, relevant state law, something that she didn't do. And this statute prescribes a 4-year statute for claims by one partner against his co-partner for a settlement of the partnership account. So, in other words, if they're going to be what we call winding up a business. So say they were going to bring Channel Red to an end. There has to be an accounting of the assets. Otherwise, how are you going to know what there is that needs to be divided between the partners in order to end the business? So they're saying that yes, there is. It's routinely asked for in these types of cases. If the court is inclined to dismiss any of plaintiff's claims, plaintiffs should be granted leave to file a proposed amended complaint. And that is something that I've had a lot of experience with. If the defendant says that the plaintiff or claims or some of the plaintiff's claims are not sufficient and that the court should dismiss them, rather than just dismiss it, the court will usually allow the plaintiff to make an amendment of the complaint to better state the claims to satisfy the defendant, basically. And then they say defendant's request for attorney's fees, which I think is absolutely absurd. Defendant requests an award of her attorney's fees pursuant to a particular statute. It says, however, a fee award would be premature regardless of how the court rules on the motion, because defendant does not seek dismissal of plaintiff's claims for breach of contract or breach of fiduciary duty, or plaintiff's request for appointment of a receiver. Therefore, parts of this case will survive even if the court dismisses any or all of the individual claims on which defendant seeks relief. Accordingly, even if the motion is granted, there would be no basis for finding that defendant is the prevailing party, which is required for a fee award. So, in other words, even if the court dismisses some of the lawsuit, the parts of the lawsuit that would ultimately survive still mean that the lawsuit goes forward. So why is she entitled to attorney's fees for having to argue to have it dismissed? That's just absurd. That's just, that's just, in the course of business, people, that's just part of the process. And it says, for all the foregoing reasons, defendant's motion to dismiss should be denied in its entirety. And that I heartily agree with, because I don't think that there is anything in his complaint that should be dismissed at this point, because we don't have the evidence. The allegations all sound plausible to me. We're going to have to wait and see going forward. I'm sure what's coming next is he's going to file a motion to dismiss her counterclaims, because that's usually, it's a very long process, people. Don't believe everything you see on TV. Court does not go the way that television shows show it. You don't have something happen and then 2 weeks later you're in court getting your case argued and then decided like within a 30-day span. These things can go on for 1, 2, sometimes 3 years or more, depending on what's involved in gathering the evidence. And, there's depositions and discovery and all kinds of stuff. So this is not going to be wrapped up quickly. And like I said, I think the next thing that you're going to see, and I'll keep you posted, is he's going to file a motion to dismiss her counterclaims. And then, of course, they'll have to respond to that. And then we'll probably get to the discovery phase, where they're actually going to have to start sharing evidence with each other that's requested, because they're required to, depending on whether it's relevant. It has to be relevant to the case, but they can request answers to questions and they can request documents, and the other side has to comply. And that goes for both parties. So it's going to be a process, so we're going to have more to talk about, but I'm interested to see what his motion to dismiss her counterclaims is going to say, because I'm sure it's going to be just as well put together as what he's filed so far, compared to her Do We Cheat Him and How really lame pleadings. Sorry, that's my opinion. I can't believe that with all her money, that's all she could afford. So I'm not sure why she's using these attorneys. They don't seem to be up to the task, in my personal opinion. We'll see. Anyways, thank you guys so much for all of your support. And again, thank you to those people who have shouted us out. I really appreciate it, you guys. And I'm happy to share information with people. And all I ever ask is that, people give me a shout out or give me some kind of credit. And these people have done a wonderful job. So thank you, Atozi, who I communicate with regularly and who I consider to be a YouTube friend, if you could call it, even though we've never actually met in person. And thank you to Alex, and thank you to Tamimi for mentioning me. And I know there were some other people had pointed out to me, had mentioned me. I'm really grateful for all of that support. I'm grateful for your support, most of all. Please like and subscribe. Thank you so much to all of our Patreon patrons who helped me bring Sybil, like I did today, which I have to do a couple times a month now, to get her injections so that her mouth flare up goes away. That's what the Patreon patrons and the channel members, that's what all of your support helps me do. I appreciate it. I appreciate you. I'm sure we're going to have more to talk about. I think I have something about one of the Ace family's lawsuits that I need to do a video on, which I will do in the next couple of days. But in the interim, take care of yourselves, love one another, have a happy Halloween, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.